I'm going to change my mind without offering you the opportunity to withdraw the plea. So if I said I'll go along with 6 months probation, then I'm going to go along with 6 months probation. She's not the prosecutor, or she's not the judge. I'm cutting it both ways here. I'm not going to go along with the 26-week recommendation because it doesn't merit it. I'm sorry, I'm not giving them a personal bond. 4,010%. You have to post $400. So come on up here, sir, if you would, please. So I need to advise you, Mr. Malmston, your name, sir? Good morning or good afternoon. As I was heading to my chambers just now, I was handed a sheet, a paper that you wrote to me, and they said that you didn't want me to share it. If I read this, I have to let the defense see it. I want you to know that. So you understand I'm going to read it.
If I have just one moment.
This is an email that was sent today, it looks like, at 1 o'clock and 51 seconds. It was sent to Laura Dodge.
Your Honor, that is the statement, the victim impact statement that we,
So what I'm trying, I get it. Hang on.
Yes.
What I'm trying to tell everybody is I can't have secrets here. So I will, if I'm going to read this, he has to understand I'm going to let the defense, I'm either going to read it out loud so they can hear it, or I'm going to give them an opportunity to read it.
Your Honor, he did not want to say it himself. We asked that the court say it. So
It's fine.
you may read it aloud.
Okay. So your client pled guilty to domestic violence under 76948. And this is the page that I received. Your Honor, thank you for allowing me to speak. My name is Anthony Malmston. I've been with Mindy for 25 years and experienced over 2 decades of verbal, emotional, financial, and physical abuse. Looking at the past year alone, there have been 5 domestic violence incidents involving me and our 3 children. She's caused fear and instability for our family. The children were present during all of these incidents and were physically and emotionally affected at times. As a result, the children and I are in long-term therapy and receiving ongoing treatment for complex PTSD stemming from years of abuse. I am not here for a revenge, but they ask for meaningful accountability. Given the number of incidents and the impact on our family, I believe the proposed sentence is far too light. I respectfully request a comprehensive mental health evaluation, mandatory anger management counseling, and regular drug testing. I also ask that she follow any doctor-recommended treatment plan, including remaining compliant with prescribed medications, which has been an ongoing struggle. Our family has relied heavily on First Step for support and counseling services. I ask that she be required to contribute to the Victims Fund to support future victims, John. I also request that the no contact order be upheld, extended, and strictly enforced, as she has been accused of violating it 3 times in the past 6 months. My priority is the safety and stability of my children and family. I ask the court to ensure accountability along with the appropriate treatment. Thank you. Ms. Holloway, correct me if I'm wrong. There was no alcohol involved here, was there?
I'm just going to take a second to confirm.
Please. I read the report. I do not remember seeing any mention of alcohol or drugs being involved.
There was no.
So that, just so everybody knows, I don't order that kind of a no alcohol or drugs unless it had something somehow, some way to do with the incident. There's no indication that it was here. Have you had a chance to review the screening and the pre-sentence report with your client? And are there any material additions, corrections, or deletions?
Yes, Your Honor. So I guess one thing to address is we placed this. I know we came in on Zoom kind of last minute right before the trial to put this on the record. at that time, the offer that was tendered was 7694A for a 6-month probationary period. You said you would go along with that. You actually brought here the victim in this matter, and he said that he was in agreement with that as well.
Did you have a 6-month agreement on this?
Yeah.
I don't usually do sentence agreements. I can tell you that. Okay, that's what you're recommending. Did you take that as a sentence agreement?
Well, yeah, well, yes, and then when you said, I'll go along with
Let me
that.
go listen to the tape. If I said, yes, I'll go along with it, I'll go along with it. I'm gonna go listen to the tape. We'll pull out the log notes. So you guys will have to be seated for a few minutes while I go on to a couple of one of these. I don't do those.
And I do know she said it was a recommendation. She said that, and then Miss Holloway, sorry, I apologize, said that this was our recommendation.
And I said,
We'll go along with that. And then we took the plea. You asked Mr. Malmston.
I don't want you telling me how many months I'm gonna do anymore then. Will you do that for me? Usually I do less than you guys ask, but I'm not gonna do less when you guys put down 12 if I can't do more when I think it might justify more. I'm not saying it does or doesn't here. I got a lot of questions in my own brain here, like a 26-week domestic violence program. I don't have that in my brain. This assault was not serious enough. Not that any domestic assault isn't serious enough. But I'm not ordering 26 weeks domestic violence batters counseling when there's a simple push. I'm not doing that.
Make recommendations as per your request. So I will.
Well, my request is always leave it to me, right? I want to be able to be the sentence. I don't do cops pleas. I haven't done cops pleas since 1995 or 6. And I'm not starting today or anytime between time now and the time that I leave. So if you really were that insistent on 6 months, I'll go listen to the tape, but you guys just have to be around here.
It's fine.
No. Is that what you want me to do?
I would like you to listen to tape because outside of all of that, Your Honor, and is the negotiations between me and Miss Holloway.
She's not the prosecutor, or she's not the judge.
I understand she's not the judge. I got that.
So that's what I understand is when lawyers start telling me what they think of do, and I'm not gonna go along with these sentence agreements. This is silly.
I understand, but what I was.
So I'm cutting it both ways here. I'm not gonna go along with the 26-week recommendation because it doesn't merit it. But if I think more than 6 months is merited, I don't want some lawyer telling me you or anybody else, you agreed to 6 months. If I agreed to 6 months, I'll honor 6 months. But it's gonna just take us some time. My regular recorder isn't here. My regular recorder isn't here. I'll be glad to look at it. If I said I'll go along with that, I might have meant 7694A. I got to listen to the context.
I mean, my memory is good, not. I remember saying that. I guess
You want 6 months, probation recommends 12. That's where we are.
well, I think if you could pass it for 2 minutes.
I'll be glad to do
Let me
that.
talk to my client because I think I think she has a different concern really than the length. So if that's the case,
I'm going to be fair with her.
I don't dispute that, Your Honor. I've been in front of you for 13 years.
I know. Okay. You can talk to her, but honestly, if I said I don't want anybody to walk out of here thinking that I'm going to change my mind without offering them the opportunity to withdraw the plea. So if I said I'll go along with 6 months probation, then I'm going to go along with 6 months probation.
No, absolutely.
You know?
I fully understand that.
Okay,
Just give me an
have a conversation, take your time. I'm gonna real quick take Rakeem Deshaun Gadsden, 25F244729. Plant Rock's here this afternoon.
Yes.
All right. Come on up here, sir. Your name? You're charged with driving on a suspended. You have the right to a lawyer. Do you want a lawyer?
Yes.
Where you been? Why is it taking you 6 months to come in here? I'm gonna give you a lawyer. You can talk to your lawyer about what you're gonna tell me as to why you were so late. We're not a restaurant here, okay? Got it?
Yes.
I'll give you a lawyer. Flat Rock prosecutor's here, right? Yeah, I saw Mr. Keeley. All right, we'll set you up with a defense attorney. Go out in the hall. He'll set you up and you'll be all set, okay? Summer Great House. Summer, Lori Greathouse, 25F245336. Give me 1 second, Mr. Lawrence. All right, your appearance,
I'm here to call on Representative, right?
ma'am, your name?
Summer Greenhouse.
This is going to be a plea to operating while visibly impaired, correct?
That's right.
They're going to dismiss the operating while intoxicated, correct?
Correct.
Correct me if I'm wrong. Somebody dropped the ball here. This is at least your third drunk driving. Right?
It's true, but the first two is she was in her early 20s.
I'm just telling you what the law is and what I see. I mean, I've seen them enhanced from 2002, 1996. I don't write these laws. They don't talk to me about them. But I want her to understand they could have charged a felony. And I want her to understand if you don't get into sobriety court, you're going to go to jail on this. Do we understand one another? So does she understand that? Have I alluded to? So you understand what sobriety court is? Could you talk to the sobriety court probation officer?
Ms. Wilds?
Yes. So you understand that when we do this now, I'm going to put you on a bond conditions. She's going to put you on bond conditions, essentially. You're going to start going to treatment. You start testing 3 times a week at your own expense. You're going to have a sober link device, which you already have. I believe I would have ordered that. If I didn't, I dropped the ball. She has a sober link, right? You're going to be going to AA. You're going to have to come to status review hearings with me every other week. And in the off weeks, you're going to have to meet with probation. This will go on for 2 years. We'll put you through a bond phase. And after about 5 weeks, the team will meet. We have defense lawyer, prosecutor, treatment specialist. We're going to decide whether or not we're going to accept you. And if we accept you into the program, that's great. I'm not promising I won't send you to jail if you get in, but I am promising you I will send you to jail if you don't get in. Do we understand that? You still want to take this plea? I'm just trying to be upfront with you here. Do you understand everything? If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all 4 points, license suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand an advice or rights form here today? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Any questions before I go on? To the charge operating while visibly impaired, how do you plead?
Thank you.
On December 11 of 25, were you operating a motor vehicle on East Trent River Drive near Sheiks Flat Rock at 11:53 p.m.? Prior to that, did you drink alcohol? And if so, what did you drink and how much? I need you to keep your voice up.
Was drinking White Claw, and I probably had 7.
And what else? What else did you drink? Nothing else? Just 7 White Claw? You were pulled over by the police, correct?
Yeah.
Why?
I'm not sure.
Do you think you did anything wrong in the operation of the vehicle? Were you swerving, weaving? Was there an accident? Did
It
you?
was not an accident. I may have been swerving.
Do you think you were swerving?
Yes.
Do you think you were swerving at least in part because of your alcohol consumption?
Yes.
Was this was a blood test, wasn't it, counsel?
Yes, ma'am.
Do you stipulate that the reading of 0.271 was an accurate reading?
Yes, sir.
Are you on probation or parole right now?
Yes, sir.
Anybody force you to plead guilty? All right, please accept the operating while impaired. The OWI is dismissed. There's agreed upon cost of recovery of $225. I'll make a note that this is going to be sobriety court. We're going to do a screening and assessment. Now, I'm going to order that your vehicle be immobilized as I must because you got a prior 2 years ago, 2.5 years ago. So I have to order a mobilization of your vehicle. So you're going to have to call a company. We're going to give you the order. And it's going to put, you're going to have, I'll give you the minimum. It's 90 days. So you're going to have a club put on that steering wheel within 7 days by March the 10th. We'll prepare the order down the hall. Make sure you get that. Now, I'm not excited about the fact that you were drinking in violation of the bond conditions. I'm gonna let that go. But you gotta get back up. You're gonna die if something bad, this is crazy, okay? You seem like a nice lady and all that, but you gotta get your life in order here, okay? So we'll do it through sobriety court. You're actually gonna enjoy the program if you embrace it. If you don't embrace it, if you're fighting it the whole time and going home every day saying this is miserable, I'd rather spend 365, actually 730 days in a dentist's office getting root canals every day. You follow me? So I need you to embrace it. If you go through this bond phase and you say, I just don't want to do this, that's fine. I just, there's going to be severe consequences to that. But I wouldn't go through sobriety court to send to just appease a judge or my spouse or my friends or my parents for 2 years if I thought it was the worst thing in the world and I wasn't intent on getting myself some lifelong help. And I'm being honest with you. Okay? Because the whole concept here is we got to get you away from this because, you're only what, 38? Three's a lot. If they'd have enhanced this, there are judges in Detroit that would have sent you to jail. You were convicted of a felony. A lot of them, okay? So I'm just telling you. So we'll give you a sentence date. You get the immobilization order. Let's get going. There's no reason for you to be scared. Just embrace the program. Believe it or not, I'm on your side. Okay? All right, give me a date if you would.
Judge Hubbard, did you want this out a few weeks?
Yeah, I'm gonna think like the 12th or 14th or something like that of April, around there.
Okay. And you have sobriety court on April 15th?
Perfect. We'll make it at 8:30.
On April 16th, right?
15th. You said 15th, right?
Correct,
Yeah.
Judge.
You can't do the 15th? What if we do the 14th? Can you do the 14th?
I think so.
Let's make it the 14th at 8:30. The more that we put it out there, the more she has to pay for her own testing and sober link and that kind of thing too. So I don't want to go any further than that. Okay? You all right?
Thank you.
All right. Thank you both. Good luck. All right. Come on up. What do you have, Mr. Mace? You got something?
Teasdale, Your Honor?
Is that a real quick one?
Yes.
Where's the file? You have the file?
Prosecutor brought it in, I thought.
Okay, give me 1 second. Did you figure out what you want to do? You want me
Yeah,
to,
we're gonna proceed.
you sure? Because I'll go listen, and if I said that, I'm telling you, I will not go back on my word.
I told you both that, but
All right, let me talk. Lauren Rose, Louise Teasdale, 25F245343. Good morning.
Thank you, Judge. William Mays, on behalf of Ms. Teasdale. Ms. Teasdale, say your name.
Is this a first offense?
Yeah, and
She's-
we're still waiting on discovery. We had a pretrial a few weeks ago. I'm gonna send over an email to remind the prosecutor.
All right, so second, all right. Pretrial date, couple weeks out. March 17th, good?
I know I got some stuff that day, but let me,
Are we going to trial
Judge-
Oh,
on this, Mr. Mays?
nope, what?
Are we going to trial on this?
I think, no, it's just a question as to how generous an offer the prosecutor's gonna give me.
Judge, it would be March
Yeah.
19th for Flat Rock.
March 19th,
19th. 19th I can do.
8:30.
8:30?
You want me to do 9?
I thought we were doing afternoons.
I don't do afternoons.
It's,
I mean, I am today because I'm gonna be out of town tomorrow. We had to reschedule the docket.
no problem. Thank you, Judge.
Can you do 8:30?
Yeah, I can.
Okay, 8:30 on March 19th. Did I already sign your discovery order?
I don't think it even required an order. It was just a demand.
Good enough, good enough.
Thanks, Judge.
Go, take her down, she'll get her
And
notice.
now I'm gonna start to ask for cops.
No, I
When
don't-
I hear this,
I,
I'm gonna start to ask one.
I said I don't do
Oh,
cops.
that's what I want to ask. Thank you, Judge.
Mandy Lane, Malmston, 25B722119. I need your appearance too, Ms. Holloway.
That's Nora Holloway of Department of Legal, PA 6528.
Ready again, Your Honor.
All right, come on up here. Your name, ma'am?
Mindy Malmston.
All right, counsel, your appearance.
Nicholas Darren, the defendant who stands my record.
All right. You've reviewed the report, right?
I have, Your Honor.
Any material additions, corrections, or deletions?
No, I just have some things to say.
Sure, go ahead.
So, Your Honor, this all has arisen, and there's a relatively nasty divorce case that's going on as well alongside this. This case in conjunction with, I don't litigate the whole divorce case, I'm sure you've seen this enough times. There's been issues with the minor children, people not following orders, houses are being ordered to be sold, things of all that nature that have, pumped up the animosity in this case, as well. Your Honor, I think you nailed it on the head, when you looked at the report. I would say the video is similar with the officer's conversations with the victim in this case. I agree with you. I don't think that the 26-week domestic violence program is necessary in this one. There was a order in the family law. One thing we did discuss was contact pursuant to the Third Circuit Court, because there is orders in place that allow her to see her minor children. I'm not even gonna get into how that's been going because of various outside factors, but Your Honor, at this point, these parties are essentially electricity and water. If my client said the sky was blue, the victim would disagree. If the victim said that water is wet, my client would disagree. Me and the counsel in the divorce case are doing our best to try and bring some sort of sanity and semblance to this case. They've been urged by the Third Circuit Court judge to try and put down their swords and come to some resolution. We are going to mediation, I believe later this week or early next week, with where I have hopes that we'll reach some sort of settlement in this matter. I'll be honest, Your Honor, I don't think you're gonna have any problems with my client on probation. She has no prior record of any kind. I think she's gonna be a model probationer for you. I think she'll be in compliance. She works full-time for the United States Post Office. And she wants this behind her as much as possible. She wants to move forward. At this point, she's come to some realization with the other case that there has been damage done that's only time will heal. And no matter what she wants, it's not going to happen at that certain rate. So, Your Honor, I'm just asking you, obviously make some corrections to the recommendation, but I do believe that whatever term you place her on probation, this will be the last time you see her. I don't think there's going to be any issues. These two parties, I understand that there's a request for a no contact order, but these two parties are going to share legal custody of these children. They're going to have to communicate about these children. They're going to have to communicate to do parenting time, to do exchanges if something happens to a child. So if this court continues and just does a flat no contact order, I'm sure you'll be back. You'll see Mr. Malmsteen come in here and say that there's been contact because, oh, my client went to the school or something like that to see her kids and he was there. Or, oh, they had a conversation because the child was sick and she needed to relay that information to him. So I just, as I'm sure you've seen countless domestic violence like this before in front of you where there's a pending divorce case and you understand the heightened level that the parties give it. But at this point, Your Honor, my client, like I said, will be a model probationer. I don't think there'll be any issues. And I ask you to follow the recommendations with some of the modifications as I had mentioned and you had mentioned previously.
Can I ask you a question, sir? Do you mind coming up here? Or would you rather not? Come on up.
Yes, sir. Your Honor.
Your name? I'm looking at this report again, and there's like a supplement that talks about Norco and Adderall.
Yes, for the last 10 years, Mindy has made me give her half of my medication every day,
That's not true.
which is illegal. Yep. She's suffered from many alcoholic and drug problems throughout the 25 years and been in treatment.
Have you been in treatment?
No, sir.
She reported to your probation department that she's with Dr. Yee and that she gets a medication. I mean, that's not, I didn't correct it because that's what it is. I mean, she is openly disclosed that. So again,
I've seen Dr. Yee for 10 years.
Your Honor, like I said, this one hits my top 10 list as far as divorces in 15 years. So, and I mean, we can, like I said, I'm not really interested in litigating the case on the whole thing, but she hasn't seen her kids since this incident. And
Your Honor,
there's, go ahead.
if that's in the report, I have no objection to a recommendation for treatment. I don't see any harm in an evaluation.
But what's the treatment? She's already with someone who she's been treating with for 10 years.
Well, I'm not worried about that. She's gonna continue to treat with him. That's not the issue. I don't even need a psychological evaluation. I'm concerned about this additional interview that I'm just seeing.
But, and if it's the additional interview, I'm thinking that's when he came back to the police department after the fact to then info dump an additional set of facts, which I'm, again, out of respect for him, I'm not going to bring up most of them. So, Your Honor, like I said, there was an arrest. There was this report, which is the initial report. And then he comes back with the eldest child, who him and her have been in here at every court appearance, posting on Facebook, taking selfies in your courthouse about how they're here to put and take care of the wrongdoer. So, I mean, Your Honor, like, when I say top 10, I've done thousands of divorces. It's everything.
All right,
Rightfully made a report. He went back and made other reports, so that, I believe what you're looking at is a part of other reports. Or other reports were made from that supplement. So if there are allegations to that, again, I don't see any harm in an evaluation, and I would have no objection to your recommendation for that.
I'm talking about abstaining from the use of alcohol and drugs. I don't see any incident where this was involved in this incident. In other words, I don't see any reference in a report where she was under the influence of alcohol or drugs or both at the time of the incident. He didn't say it then. He's talking more about past history. What I'm going to do is this. Do you have anything else you wanted to say?
Just that I did review the PSI. It does say 12 months. Nick and I did speak about, or Mr. Darren and I did speak about 6 months. But for the record, I have no objection to the court following the recommendations of the PSI. If you so choose.
How old are the children?
They're well, eldest is 21, and there's 14 in.
I don't care if they're 21, 14, 8, or 56. You guys cannot get your children in the middle of your issues. You cannot do that. That is so incredibly harmful to a child who loves, I'm certain, both of her parents or his parents. You cannot do that. I don't care how much you want to do that. I don't care how much satisfaction you get out of turning a child against the other parent. And I'm referring to both of you. You cannot do that. That cannot happen. I'm not talking to anybody in particular here. I'm just talking to both of you. 9 months probation. If I let you finish, did you want to say anything else?
No.
I mean, if there's one thing I've agreed with is what Mr. Darren said about the circuit judges, including them to put their, or encouraging them to put their swords down. You cannot do this, folks. Okay, so you're not happy. People get divorced in this country every single day. Not just one couple, probably thousands. I mean, I don't know what percentage of marriages work to the point that they last forever, but okay, so you want a divorce. I get it. Maybe one of you do, maybe both of you do, maybe you both of you can't stand each other. You cannot harbor ill will toward the other in front of your children. It is damaging. 9 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to report as directed. I'm going to order that you continue your mental health treatment at the facility approved by probation. I'm going to order that you attend the domestic violence weekend program. This assault doesn't rise to that level of requiring 26 weeks. No contact with the victim except to effectuate visitation with the minor children in accordance with the order of the Wayne County Circuit Court. I can't believe, is there an order sharing custody at least right now?
We,
Did you guys have a hearing on that?
we haven't had I filed a motion for parenting time and Judge Farr had just ruled and ordered parenting time and joint legal custody and said this, and then sent us to mediation, which is at the end.
So you got, there is an order from the
Yeah,
circuit
there's
judge.
For parenting time and.
Okay. So you got, there's to be no contact except to effectuate visitation. I would like to think you two are adult enough where you can at least communicate with one another. I'll pick them up at 6. I'll drop them off at 4, whatever the case may be. But that's the order of the court. You're not to possess any firearms. You're not to possess any dangerous weapons. You're to serve 4 days jail credit, 1 serve 3. I'll let you serve those with community service. I'm going to give you till April the 30th to complete 24 hours of community service. We're going to give you a prosecutorial review date here in a minute. I'm going to order that you pay fines of 100, costs 200, 75 victims' rights fee, $50 justice assessment. So fines and costs are 4.25. Probation fees are 180 for 605, and then you have screening fee of 60. I'm not going to order the court work program. 665, if you violate, your probation could be revoked. I'm taking it under 7694A, as I said. If you comply, the case will be dismissed on motion of the prosecutor. The only agency that will be able to see that are police officers, judges, prosecutors, nobody else. It'll be a non-public record for all time. If you're compliant, the case is dismissed. If you violate, you can become non-public. Like I said, your 769 status could be revoked, and then it will go on your record for all time. So, do we understand the sentence? Anybody have any questions?
No questions here.
Can she pay that today? 665.
A couple hundred today, Your Honor, but we should be able to get that taken care of, within 30.
I'll just give you till April 15th to pay it. Can you do that? You pay 200 today and then the balance by April 15th. You'll meet with probation. Give me the review hearing date, if you will. Heather. So it should be out in
December 3rd. I'm sorry, Judge, I was muted.
December 3rd of 26 at 8:30. You don't have to come, Mr. Darren, if she's compliant. Okay, anything else? Did I miss anything, Ms. Alway? Mr. Darren, anything else?
Nothing further. Your Honor.
Ma'am, anything else? Sir, anything else? And I wish you guys well. I truly do. Hopefully, you're going to recognize children are much, 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 much more important than we are. Good luck. Thank
Sir, do
you.
you want me to take her to probation first or?
Yeah, take her to probation. Thanks.
Thank you.
Christine Francis Luce, and then she has to go down and get the, right. Christine Francis Luzinski, 26F245459. All right.
Good afternoon, Your Honor. Leslie Aycock, on behalf of the defendant who's present to my right. Can you please state your name for the court this morning? Christine Lazinski.
All right. We're going to do March. Your name, ma'am?
Christine Lazinski.
I'm sorry. Okay. March 19th at what time? Heather?
We can do, how about 10:15?
Good?
I'm sorry, I have a 10:15 circuit court hearing in front of Judge Ivana Abraham at that exact time.
Let's do it at 8:30 then. How's that?
That would be fine.
March 19th at 8:30, okay?
Thank you.
And I'll be here, and I know Mr. Cayley shows up timely. Thank you.
Sounds great.
Have a
Thank you,
good
Your Honor.
day.
Have a good day.
Thanks. Drew, Richard, Dupre, 25F, 245, 129, A, B, and C. Good morning, or afternoon, Mr. Clovis.
Good afternoon, Judge Bill Clovis, P 38434. On behalf of the defendant, sir, would you please identify yourself?
All right, so they're gonna dismiss the resist and obstruct, and he's gonna just plead the speeding, and they're gonna dismiss the defective equipment, and the prosecutor adds that the medical reason is, the window tint. He has a medical reason for window tint, and that's why he's doing that, right?
Correct, the R or whatever is being dismissed, the window tint. is
Right.
Dismissed, the 16 to 20 is being dismissed to a 1 to 5, a 1.30 and a 25.
All right, and is that what you want to do, Mr. Dupre?
Yes.
That's 1 point, and then I'm gonna dismiss the speeding 16 to 20 over. I'm gonna dismiss the defective equipment and the resist, hinder, obstruct an officer, right? Is that what you want to do?
Yes, Your Honor.
To the charge 1 to 5 over, which is 1 point, responsible or not responsible.
Responsible.
Okay, I'm gonna accept that plea. I could dismiss the defective equipment. I'm going to dismiss the R and O, and I'm gonna charge $160 on the speeding. So I'll accept that plea, and I'm dismissing the 16 to 20 over. Have a good day.
Thank you, Judge.
Thank you.
He can pay that today.
Okay, good enough. Thank you.
All right, thank you.
Have a good day.
The window.
Thank you.
You have a good day too,
You
Judge.
do. I try.
And, you know, I know you, because Betsy, justice is tiring.
Take care. You too. Do I have anything else down there? Oh, she said something about another file that was sitting there, but that's up for tomorrow. You didn't take that, did you?
Which one?
She put something, I don't get her saying it.
Oh, was that?
Okay. Oh, geez, what did I do? Heather, can you hear me?
Yes, Judge.
There's a case out of Woodhaven, they want an adjournment for more than 3 weeks. I don't mind doing it. Can you pick me a date out and I'll write it on the,
So after 2 weeks, our next date is April 1st.
that's what I'm gonna do, April 1st. We'll do it 8:30. To retain the lawyer.
Yeah, sure, yeah, that works. We don't really have anything that day yet.
I'm sending this down with John next time he comes down and I sign the order adjourning that
Okay.
case for a month. What do you folks have? You got something? What's your name? How about you?
As it earns.
Did you guys check in with my court officer?
I think with Derwin.
Oh, I see.
Just done.
That's actually
I'll just-
that's what would happen. Or Lisa, actually.
All right.
She brought it down. I don't know who gets that. So I'd take it to Lisa first and she brought it. Well, I don't have anything, folks. As soon as I get something, I will be out of here, okay? I'll be out. Stay seated, please.
How you doing, Ace?
Hey, how are you?
What's that?
Jacket box, right?
Yeah.
Skills box, right?
In Russian, do they have a few weeks at Inland Park?
That's
This patient work, do they often the weeks?
2 on, 2 off.
2 on, 2 off.
Yeah.
So who do we have next week?
Oh, think Rich is going. You go on 2 on, I say, no, let's move on. March Madness. He can bring you.
It's only the 10th.
He's not going that Tuesday, he's leaving this Friday, Saturday, Sunday, something like that. He'll be going the Father.
Is next week,
He will be, but he's not.
it's not on.
No, he's not, just was his last.
I mean, I like that place to go. He's on in the second and
Oh, yeah, Rich. Oh,
it's just like smooth.
oh, yeah, he's done it. 10:30 today. Yeah, which was good, because I think it's.
He takes them up from, gives them nice time.
Right, yeah. Oh, yeah, I got there right at 9. He was already on, the sentences and ready to go, so. I kind of like it, they kind of pile it off the first week, then the second week's not so.
Let's see. I guess there's less than there next week, is that week, 1 week.
That's week 1.
That's the most shot.
We'll be there for a while next week.
Doesn't matter, because I was happy, he's not on the call anyway.
Oh, we'll do
Doing
it.
that each conference.
Oh. Oh. So,
But then that sounds simple.
2 months, huh? You got the days? You got your time with all?
Just waking up.
I'm tired, John, look at this guy.
Yeah, I know.
Big stuff,
Mhm.
moving to Florida.
Yeah. Got in at midnight last night.
What's that?
I got in at midnight last night there.
Oh, you did?
Really?
Are you still, flying free for all your miles or no?
I burned those already.
Oh.
Those tickets, but it's,
What are you flying?
here's the thing. Southwest Regional, it's $4.
Oh,
But, in Spirit, they've been talking about going out of business.
oh, you told me that.
Right, well, now I booked a flight in end of April, and then I got an email saying that, we canceled the flight. So then I can go in and try to rebook, they canceled the whole route.
What?
So once mid-April's over, but they're not flying back and forth from Florida, when I talked to them the other day, said, well, they canceled Pittsburgh, too. Pittsburgh, Florida. So I was. Yeah, I don't know what. Just talking about it, last I heard in September, the CEO said that if things don't get better, they're going out of business in the new year. And then I didn't hear anything, but it's still plays like early this year, but I think they're Jason.
Wow.
I mean, if they gotta redo their routes and. To the one.
Seated, please.
Quarterback.
Okay. People against Daniel Conway. 25F 245 159 A and B.
Thank you, Honor, Thurman, thanks again for Daniel Conway.
Your name, sir?
Daniel Conway. Just bring a post release.
Yeah, it's going to be a plea to false information with the suspend to be dismissed. True? Is that what you want to do, sir? If you plead to that, the possible penalties, I'm talking about false information, are up to 100 fines, 90 days jail, costs, or all those. Do you understand that? Did he sign an advice of rights
When I first came to court, you know.
today?
We went through that today.
Yeah, I need one. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. If you plead guilty, you're giving up your right to a contested trial of any kind. You're giving up your right to a jury trial, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights. And we're not going to have a hearing or a trial. Do you understand that? To the charge false information to an officer, how do you plead? Would you give him a name different than yours when you were pulled over by the police on December 10 of 25? And that was in Flat Rock, true?
Sir.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Plea is accepted, suspense dismissed. Anything, counsel, before you?
Sure, we would ask to just find some costs And he's working something out on another pending case in Monroe, so he's got a courtroom kind of open right now.
Anything you'd like to say, Mr. Conway?
I'd just like to apologize for being stupid. That was just the stupidest thing I've ever did.
100 fines, 50 costs, 70, those are your words, not mine. 100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 60 days. Can you pay that now?
He's got 150 now. And like, what are the chances of that?
Yeah. 150 now, and can you pay the rest by March 17th or not? March 24th?
Could I get to April? I know I'm gonna have money in the.
April the 5th. Okay? All right, good luck. If you need more time, don't get panicky, call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you.
You're welcome. Gadsden, Rakeem Deshaun Gadsden, 25F24729. And could I have Montgomery and Ernst seated up here, please?
Sure, well, thanks to Mr. Gasson.
Sir, your name?
Peter Gasson.
All right, we're gonna he's gonna get arraigned. Does he stand mute, wait formal reading?
Yes, secure.
Not guilty, pleas entered. $300 bond is continued. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'll give you a new pretrial date. Don't miss again, okay? We got each other?
Yes.
All right, give me a date with them, Heather.
That will be March 19th at 10:15.
March 19 at 10:15. Okay?
Okay.
Go down the hall, get your notice, and you're all set. Wish you well. Best of luck. Olivia Boyan Montgomery, 26F245361.
Sure, well, thanks to Ms. Montgomery. They have something.
Ma'am, your name?
All
All right, your client pled guilty previously. She does have warrants. She pled to impaired driving. The OWI was dismissed. She was referred for a screening and assessment. Have you had the opportunity to review the report with her, and are there any material additions, corrections, or deletions?
So the report's accurate.
Anything you'd like to say on her behalf?
We asked the court to adopt the recommendation, anticipating there's going to be some funds and costs as part of it. She says she can pay $100 a month right now. I think over the extended duration, hopefully she can pay more sooner than the baseline.
Well, you really had a lot to drink there. What would you like to tell me?
Judge, can I have a minute? Because she wants to tell me something and I can't hear whispers right now.
Go ahead.
We'll just step right in.
Pull up the record. John, those cases that I gave you, those probation violations, who has those?
He told me to give the probation. Or no, there were no shows.
All of them?
Yeah. The ones you gave me this morning were no shows.
No, I'm talking about the ones I brought out this afternoon.
Yeah, there were no shows.
Okay. All right.
Judge, the only thing is that anticipating funds, we're hoping the first payment not to be due till maybe April 1st.
Anything else you want? You want me to take out a public apology for in the News Herald, or I'm just kidding.
Now we're ready to move forward.
I understand. What would you like to say?
I'm sorry, Your Honor, for that night. It was a terrible mistake, first and last time, so you won't see me again.
What worries me here is you scored, it's the scoring. You scored in category 3 and 4, but you really had a pretty high one here. Blood draw, right?
Yes.
It was a blood draw. So where do you live? What city? Flat Rock?
Yeah.
"12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol. You're not to purchase, possess, or consume alcohol or illegal controlled substances. No marijuana either. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation."
We're gonna touch on that. Thank you.
She does have a medical marijuana. I will not violate you. Thank you. I remembered one of those said that. You have a valid medical marijuana card. I will not violate you for testing positive for THC so long as you have proof and provide proof to probation that you have a valid medical marijuana card. Do you understand that? Kratom, otherwise poppy seeds and CBD oils are prohibited. Again, if you have a valid medical marijuana card, THC positive, I won't hold that against you. But no alcohol, no illegal drugs. I'm going to have you submit to chemical testing, PBTs and ETGs as follows. Bi-weekly for 2 months. If you're clean and you show every time, then I'm going to make it monthly for the duration of probation, okay? You're going to attend the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. You're going to attend the Substances of Abuse group through Class A Training Center. You're going to clear all of your warrants. By April the 3, I expect you to go over there and clear all those warrants. 4 days jail credit, 1 serve, 3 I'll let you serve those as follows. 1 day on the court work program, 2 days of community service. I'll give you until April 30 to complete your community service. Day court work program, you'll pay $35 for that. They'll set you up with that. And then 300 fines, 225 costs. 75 victims' rights fee, $50 justice assessment. So fines and costs are $650. Screening fee is $60 for 710. You have probation fees of $240 for 950. You have court work program fees of $35 for a total of $985. You have attorney fees of $40 for $1,025 plus $225 in cost of recovery. Everything included amounts to $1,250. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. And also, ma'am, if you get everything done and you don't have any violations, you can apply for early discharge in 6 months by statute. Legislature passed that a few years ago, so you can apply for that in 6 months. Do you understand all that? Now, how much did you say again? $100 a month starting?
A month starting April 1st. She's hoping to pay more along the way, and she is interested in early termination. But this is an amount that she thinks she'll be able to make every month.
All right, I'll let you do that. April the 1st, you pay him $100 a month. But remember, I'm not going to discharge you until everything's paid, okay?
Okay.
You'll meet with probation before you leave. Make this your last mistake, okay? Good luck to you.
I appreciate it.
You're welcome. As our Judge Juan Ernest, this is file 26F245355. Good morning, or afternoon, I guess what it is, huh?
There were days when it's very stated on separate sentencing.
All right, sir. Mr. Ernest pled guilty to operating while visibly impaired. The OWI was dismissed. He was referred for a screening and assessment. Have they had the opportunity to review the report with them, and are there any material additions, corrections, or deletions?
We'll report back.
Anything you would like to say on his behalf?
Yeah, I'm sure the court took note that this was on a point before. It's quite time we discussed that and some of things. We were asking the court to adopt the recommendation. Mr. Ernest is interested in really discussing this and everything done. I think he will in the plan as well.
Sir, anything you'd like to say?
I apologize for my mistake. I don't have to do it again and I don't have to return.
That's a lot of alcohol. You know that?
Yes, sir.
12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and ETGs twice a week. I'm sorry, bi-weekly for 4 months. If you're clean, I'll make it then monthly. You're to attend AANA twice a week until you're in treatment. I'm ordering outpatient treatment. You have to keep going to AANA twice a week until you're in outpatient treatment. Let me see your proof that you've been doing that so far. And then you're going to go to the Victims Impact Panel as well. So let me see your proof.
I have it on here.
Not good. You didn't go, huh?
I was doing that online.
You don't go. No, you're not doing that. You and I wrote in person. You just bought yourself a couple more days on the court work program. You had a high breathalyzer, a blood draw. You take me this seriously, you know where you're gonna end up? You know where that door leads to? Where?
Yeah.
Yeah, and then they come and get you and they're gonna take you. I'm telling you, don't play with me. I knew you weren't gonna go. That's why I asked you for it. I knew you didn't go. You better start today, AA twice a week, in person. Got it?
Yeah.
Who said you could go by Zoom?
Nobody, I just,
You didn't go by Zoom either. You just tell me that because you weren't in person and you didn't have a signed sheet. You're going in person twice a week until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to go to AA or NA. 6 days jail, credit 1, serve 5. You just bought yourself 2 more days on the court work program than I was going to give you. 5 days court work, there's a $35 a day charge for that for a total of $175. Pay fines $300, costs $250, 75 victims' rights fee, $50 justice assessment, $675. You have 60 in screening fees for $735. You have $240 in probation fees for $975. You have cost of recovery of $225 for a total of $1,200 plus your court work program fees of $175. That equals $1,375. You may be eligible for early discharge. If you violate, you can get 93 days. I'm going to make a note here. Did not attend AA while on bond. And then I want to show you what I'm going to do. And I'm telling you, I'm going to write this down. I'm going to take this little highlighter you see, and I'm going to highlight it. And I don't care if you violate one time, you're going to jail. You don't defy orders like that. You understand what I'm saying? You're too busy. You've been unemployed. How could you be so busy you're not going to AA? Ask yourself those questions. How much can you pay today? $100 today, and then how much a week or bi-weekly?
Because we were thinking 100 a month.
What are we're not a bank over here. I mean, I'll do that, but $100 a month beginning April the 1st. You better get some work. Aren't you working? Big, strong guy like you're only 32 years old. What do you do all day? It said you do side jobs, doesn't it?
Yeah.
How much do you make doing side jobs?
it's still season, not much.
Well, then why aren't you working at a job, a steady place of employment where you go to work every day and you go between 7 and 3 or whatever, 3 and 11 or
I'll start with you.
you don't want to be broke your whole life, do you?
Nope.
You may be eligible for early discharge. I wish you well. Grow up. Comply.
In this intense courtroom moment, the defendant apologizes for his mistake after admitting to drinking a large amount of alcohol before the incident. The judge makes it clear that the situation is serious and places him on 12 months of probation with strict conditions. The defendant must avoid alcohol, drugs, and marijuana, attend AA meetings in person twice a week, complete outpatient treatment, and submit to regular alcohol testing. The judge becomes frustrated when the defendant admits he did not attend AA meetings as ordered, warning him that ignoring court orders could lead directly to jail. As part of the sentence, the judge orders 5 days of court work program, several fines and fees totaling about $1,375, and strict monitoring during probation. The judge finishes by reminding the defendant that this process is meant to push him to change his behavior and take responsibility for his life. Question: do you think strict probation conditions like these actually help people change their behavior? If you enjoy real courtroom moments like this, like the video and subscribe for more courtroom content,